number 75, People versus Jorge Espinosa.
Good afternoon, and may it please the court. Sam Feldman for appellant Jorge Espinosa. I'd like to reserve 3 minutes for rebuttal.
Yes.
Thank you, Your Honor. This is a DNA case in which the prosecution introduced the crucial DNA evidence through the wrong witness.
Counsel, is this the elusive cold hit case that we've never decided?
I would say it's not for a couple reasons. First of all, there were, of course, 2 different DNA profiles at issue in this case. One was a post-arrest buccal swab, that was taken pursuant to a court order from Mr. Espinosa.
And a CODIS hit.
Sorry?
And a CODIS hit,
Yes.
cold hit. Did both go in at trial?
The CODIS hit didn't. It was the 2 that went in at trial were the profile from the buccal swab and then the profile from the crime scene evidence, which did have an identified suspect, listed in the OCME case file at the time.
Just to be clear, the buccal swab was from a prior arrest and prosecution.
That's
correct?
right, of the same person.
So
Mr.
how is
Espinosa.
this not the
Right.
cold case that Judge Garcia is looking for?
Well, it's a fair question. I think the sort of classic cold hit scenario is one where evidence is fed into.
It is in Austin, right? Austin was a confirmatory. They put in a confirmatory swab, right?
I believe the only difference between this case and Austin is that the buccal swab was taken pursuant to a court order for a different case rather than the same case, but it was the same defendant.
So can I ask you what concerns me, I guess, most about this case, which is it comes on an ineffective assistance claim only. Is that right?
Yes, that's right.
And so we have a brief SSM decision, People v. Rodriguez, that says, even assuming the counsel failed to assert a meritorious confrontation clause challenge, the alleged omission does not involve an issue that was so clear-cut and dispositive that no reasonable defense counsel would have failed to assert it. The only difference that I can really see between the two is the timing of when the trials took place. And unless I'm missing something, you'd have to show that something became clear by the March 2014 trial here, March 26 trial here that was not clear in the March 24 trial in Rodriguez.
Well, I think there's 2 important differences that go to the factual context as well as the differences in the legal context. Those 2 differences in the factual context are, first of all, the lawyers, and much of this is in the First Department decision in Rodriguez. Counsel in Rodriguez did object to the DNA evidence at trial, did object and made sort of, if not the perfect objection, at least an objection to much of the DNA evidence, objected to, and I'm quoting from the First Department, the introduction of reports of conclusions reached by non-testifying examiners, and urged that the admissible evidence from OCME's files should be limited to the pages of documents reflecting raw data that had been personally reviewed and initialed by the analyst in that case.
Are you reading from the appellate division decision?
Yes, the
there?
First Department. So, in other words, counsel.
The First Department, I think, considered that claim on the merits even though it deemed it unpreserved, I think, and the only thing that came to us was the ineffective assistance claim.
Exactly. My point in quoting that language is just that where counsel here failed entirely to object to the crucial DNA evidence, counsel in Rodriguez sort of did a lot more towards making that objection. But the second difference that I think is important not to overlook is that in Rodriguez, and again, this is drawing on the First Department decision, it's actually very difficult to figure out if that even was the right witness, because that witness's initials were sort of all over the DNA, the OCME case file there. So even assuming there was an error, it was sort of a close call. It was a difficult thing to figure out that there even was an error, and it's less counsel's fault for not noticing a confrontation clause problem there.
Why isn't that analogous to, is this a cold hit or not? I mean, we don't know if this is the cold hit case we've been waiting for, and we've never decided that issue.
Well, I think the real question is from the perspective of defense counsel at trial, in March 2016, was there a reason to object here? Was there a
But is
reason?
it dispositive?
Isn't
that the test? It would have to be dispositive, right? It's a winner.
I would
know if
say
that's a winner.
it was clear-cut that counsel should have objected. What would have happened had counsel objected?
It's not the standard, right? Isn't the standard that the issue is so dispositive, right? So clear-cut and dispositive, and how can we say that's a clear-cut issue where we've never had this fact scenario before?
I would say, so again, had counsel made that objection, this was in the middle of trial. Now, the prosecution could have sought an adjournment to produce a different witness, and perhaps the court would have granted that adjournment, and perhaps...
My point is, we've never decided this scenario before.
No, that's
So
true.
how could we say it's so clear-cut and dispositive? We'd have to decide it.
Well, we don't just have to look to decisions from this court. I mean, I think had counsel made an objection here, as counsel was doing, other defense counsel was doing in many other cases at the time, to
What
DNA
other
evidence.
court would you suggest we look at?
Melendez-Diaz and Bullcoming are the most important cases.
And those cases were around before Rodriguez, so that can't get us there.
That's true. So then to get to the third difference between this case and Rodriguez, which is about the legal context, it's not just about timing of 2014 versus 2016. In 2014, in the First Department, every First Department case pointed in one way, pointed against an objection. And the First Department had sort of squarely on point cases saying there's no confrontation clause problem here. But in 2016, in the Second Department, there was multiple Second Department cases pointing towards an objection and finding confrontation clause error. In fact, in one case that had already been decided by the Second Department, the prosecution conceded that there was a confrontation clause error. So it's both timing and a difference in department.
Assuming you don't think that the decision in John, or that you think the decision in John categorically answers this question, you have to at least acknowledge that pre-John, there was some question on that, right? Because it's hard to understand why the case would be in this court if there wasn't a question.
There may have been some question, and again, there was a sort of a departmental split because the First Department had been deciding cases one way, the Second Department had started deciding them a different way. This case was in the Second Department. But I think this case resembles a lot what this court wrote in 2005 in People v. Turner in holding counsel ineffective for not raising an objection. This court wrote, "It is true that there existed some New York lower court decisions that might have been cited by the people in opposing the objection there. Perhaps the law on this point was not definitively settled at the time of trial," but this court went on to say there were strong indications that the defense had the better of the argument. A reasonable defense lawyer at the time of defendant's trial might have doubted that the statute of limitations argument, which is what it was there, was a clear winner, but no reasonable defense lawyer could have found it so weak as to not be worth raising. And I think that's this case.
So let's get into that, though, for a second, because I'm having trouble understanding how post-John, assuming, you had the benefit of the clairvoyance that John is going a certain way, how this particular motion would have been such a slam dunk winner as to create a Turner error.
Well, again, I think Turner doesn't require a slam dunk winner, but I mean,
It has, we've heard the standard from Judge Garcia a couple times now. It has to be so, of such a huge nature.
Clear-cut and dispositive.
Clear-cut and dispositive, thank you.
Well, clear-cut and dispositive that no reasonable counsel would have failed to raise it.
exactly, Your Honor, yes. But I think
That's the distinction you're making. It's not that it has to be a winner, it has to be a good enough argument that if you were a competent lawyer, you would make the argument.
And do you
That's-
have that post-John?
post
Because it's not a cold hit case, and that's really that's where everything seems to go off the rails.
So if we look at the law pre-John decision, there was no New York case, at least no case from this court or the Second Department, and certainly no Supreme Court case holding that cold hits are not testimonial. In other words, that a DNA profile can be testimonial if it's from a profile generated post-accusation, but not if it's
And
pre-accusation.
there's no case holding that they are.
Well, I guess there's no reason looking at the Supreme Court cases and looking, again, at the cases this court had decided
Well,
at
if you
that
look at
time.
Williams, it's hard to take any lesson from Williams, right?
Well, there were a couple things that got a couple of sort of propositions that got a majority in Williams. There was certainly a majority for rejecting Justice Thomas's approach, for example. Eight justices rejected
I agree
that.
on that.
But there were also 5 justices rejecting the sort of quote-unquote pluralities targeted individual rule. Both Justice Thomas in his concurrence and the dissent spent some time explaining why that rule was completely inconsistent with Melendez-Diaz and Bullcoming, as well as with the common law and other precedents.
And here we have no targeted individual.
Right, so in other words, under Williams, I think it's clear that you don't need to have a targeted individual because 5 justices had signed on to that proposition, even though there may not have been much else in Williams that produced that kind of agreement. The other factor I think to consider when evaluating counsel's performance here is that there was no reason not to make this objection, for which counsel could have cited Supreme Court precedent and local precedent. It didn't conflict with any defense counsel was raising. There was no...
And I think that goes to your earlier statement, so weak as to not be worth raising, goes to that part of the test, which is, okay, if it's so dispositive, I think you can still look at, well, was there a strategic reason not to raise it, right? But you still have to get by the first part. So I think, it's not so weak as to not be worth raising isn't the standard. That's, I think, more of the standard towards, okay, do we need a 440 for this, or is it, right?
I mean, I agree that it's also important to show that it was clear-cut that counsel sort of objected. I think on this record, it was, first of all, clear-cut, assuming the Confrontation Clause applied to DNA evidence, which there were cases saying that it did, and assuming that this witness wasn't the right witness, which he clearly wasn't, I think that made it clear-cut and, on this record, dispositive of the prosecution's case. Again, this was solely a DNA case. There was no other evidence of identity. And again, I would primarily point this court to the language in Turner, which I think is uncannily similar to the situation presented here.
Good afternoon, Your Honors. ADA Amanda Iannuzzi on behalf of the respondent, Queens County District Attorney Melinda Katz. May it please the court. The question here is one of ineffective assistance of counsel, and the analysis here focuses on the state of the law that existed at the time of the representation.
Isn't this Rodriguez?
It is, Your Honor. While my, counsel references the difference in the underlying facts to a certain extent, it is obviously different from the facts here, but the ultimate fact that binds the two cases is that in either case there was no specific Confrontation Clause objection to the admission of those reports. And the issue that was presented to this court in both cases is exactly the same. It's a claim of single error.
He's argued that it wasn't that obvious that the Confrontation Clause, that there was really a Confrontation Clause objection available to counsel.
In
Rodriguez.
Well, in Rodriguez, it's true that the attorney in that case had made some objection, and there was also, I believe it was a motion from the people discussing redactions of the document, but he never actually raised a Confrontation Clause objection, specifically whether or not that report was testimonial. And that is the same as the case here. Whether or not this report, the two reports that were made.
I thought he was arguing there were reasons that are factually distinguishable between Rodriguez and here for why the counsel, excuse me, would not have done that.
Well, this court's decision didn't focus on what the attorney in that case did, or ultimately focused on what he didn't do, which was raise the objection. The decision of this court wasn't based on, well, the attorney in that case did a little bit more and kind of sort of raised an objection. He failed to raise the objection. The analysis of this court was this was not a clear-cut and dispositive issue at that time, and therefore counsel was not ineffective, even if he had a meritorious argument. And that's the same analysis that this court should take here in this case.
Yeah, in the one paragraph, ma'am, let me ask you this. What about his point regarding the state of the law in the Second Department?
Well, there were decisions, as counsel referenced, of the state of the law. Some cases had ruled for, and some cases had ruled against. I know the people, we did cite to some of those in our brief. Ultimately, counsel had a few cases to look at that were the most senior binding precedent. It was this court's decision in Brown, and it was the series of federal cases from the United States Supreme Court, Melendez-Diaz, Bull Cumming, and ultimately the fractured decision of Williams. Williams, of course, being the only case from the Supreme Court to specifically deal with the DNA issue. Counsel justifiably could look at this court's decision in Brown, which admitted the DNA evidence with no confrontation violation, and look at the analysis in Williams, where 4+1 says it comes in on two different analyses, the more narrow primary purpose test, and then also Justice Thomas's formalized sworn document rationale, and say, well, in each of those two analyses, my reports here would come in. So it would be completely reasonable for counsel on the facts of this case, a cold hit case, to look at these cases and say, I don't believe I have a viable objection.
John had also been briefed and argued by the time the trial and the underlying case occurred, right? It hadn't been decided. So
Correct.
that might have been a reason that things were different from the time of Rodriguez, no?
I don't believe so, Your Honor, and the reason for that is, as it was referenced earlier, it's that the Sixth Amendment doesn't require clairvoyancy. So counsel might have been aware of the briefing, might have been aware of the oral arguments, but the oral arguments are not necessarily indicative of how the court ultimately may rule. And certainly now, with the benefit of hindsight, of knowing how this court ruled in John, knowing the intricacies of the court's decision, the emphasis on electrophoresis and raw data, that is something that even at that time, counsel, it would not be reasonable for counsel to say, to at least to say, oh, attorney should have known that in a couple of weeks we're going to emphasize the importance of the electrophoresis stage.
What about the
and things like
trend in the other courts? What's going on in the Second Department and the Supreme Court decision in Williams? Is that a legitimate area of inquiry in determining whether or not there is a Turner error taking place?
Well, I would say Turner is a very distinguishable case because that was a black letter law issue. There was law that, although it was from, I think, like 100 years prior, it was still nevertheless in existence and on point at the time of the representation there. So the fact that things are changing and decisions were in the works and there's fractured opinions, I think is very relevant to the analysis of what is going on at the time of the representation here.
So would you say that should have motivated defense counsel to make the objection more?
I think if there were a different set of facts here, then potentially the answer to that question would be different, that counsel should have raised the objection. But as was referenced earlier, this was a cold hit case. It was a DNA report that was generated before the
But what
defendant
about
here.
his argument that 5 justices in Williams rejected what would be the foundation for such an argument?
Well, I think that the fact that all 9 justices of the Supreme Court couldn't agree on an analysis for or against admission of the document certainly underscores that this was not a clear-cut and
Well, yeah, they
dispositive
could in
issue.
that, I get your point about that, but what about the argument that there are 5 justices who are rejecting the foundation of the argument on the cold hits?
I think then that the plurality of that decision, I think, becomes very relevant when you then consider that in connection with this court's decision in Brown.
But
There
isn't
was,
what you said before, it's the plurality in that situation plus Thomas being the swing vote, kind of like the circuit is doing in Garlic, right, in a different context, but you have the 4-judge plurality on that issue, plus you have no ribbons and stamps under Thomas, so you get 5 votes.
correct. And could counsel have raised the argument there relying on this fracture decision? Yes, he could have. But I think that the facts of this case, the decisions that existed at that time, and then the possible strategy of counsel knowing that, if I raise the objection, I ultimately win the objection, that then opens the door for the prosecutor to call in whichever witnesses they need to get the document into evidence to avoid the confrontation clause, and then overwhelm the jury with evidence on the validity of those test results. And by doing that, counsel in this case, when you examine the strategy he did take, he would have lost an avenue of attack, which was what he was trying to do. It was a two-pronged attack on the evidence.
So
It was.
you mean when there's an obvious, when it's obvious, or even you would agree it's obvious, counsel should have the strategy not to raise the objection because the ADA might actually be able to address the deficiency?
Well, I think that the strategy here in this case, it was important. It was certainly a factor, but ultimately, I think that based on the facts of this case and the law that existed at that time, the counsel it was completely reasonable for him to ultimately conclude that he did not have a viable objection.
So counsel here chose a different tack, as you say, and it was a powerful one, right? It was bad collection of evidence. The evidence was moved and no one told the officer who was collecting it. He took a gambit on that. And I understand your argument to be that, that's why he chose not to raise the confrontation argument. My response to that is, why not do both? I mean, you could certainly argue this in the alternative, so why not do it?
Well, I think what Your Honor is getting to is essentially looking at it now with the benefit of hindsight.
Is that it?
I think it's a sense of essentially Monday morning quarterbacking, for lack of a better term, to say, well, counsel could have just done this and he would have been fine either way. I think.
So it was a
looking at the-
legitimate strategic decision on his part to just say, you know what, I'm not going to bother with this motion that I don't think I'm going to win. I'll focus instead on this other aspect.
I do believe it was a legitimate decision of him, based on the law that existed at that
we
It
time.
is a
get to
little
that
bit different
point?
because he's basically making all of the arguments to the jury that he would have made to the judge.
Well, an attorney may not necessarily have an argument that against an admissibility of a certain piece of
No,
evidence,
but going to Judge Canataro's point, why not do both? I mean, you've already, it's obvious the lawyer had thought this through, right? Had thought about what are the problems with this particular testimony that I want to attack, right?
Well, I think, to go back to my earlier point, he certainly could have. He could have made an argument against ineffectiveness, or I'm sorry, an argument for admissibility, and then later on argued the weight of the evidence, the strength of that evidence, could argue that the people didn't bring in the right witness. Ultimately here is, do we have to essentially look at the entire performance of this attorney and throw it into the garbage because he didn't do that single act?
Sorry, go ahead.
Oh, just to finish that thought, it was just basically to say, ultimately here, we do not have to completely throw all of his effective representation, which is undeniable on the face of the record, into the garbage can because he didn't do the single act, because the issue at that time was not clear-cut and dispositive.
Would your answer to Judge Canataro's question be the same if this arose after John was decided?
No, I don't believe so, and that's because that this is a cold hit case, which, as Your Honors had mentioned when my opponent was arguing, is still a question that is left unanswered even after John. So while John might have stirred the pot a little bit more, it certainly would not and does not appear to answer this question of a cold hit case, which is the facts of this particular case here.
So your view is that it has to be clear cut that the objection would prevail in order to require that it be put on the table?
I think, Your Honor, is just kind of reformulating the standard, which is it a clear-cut and dispositive issue? So I think either way you say that statement, it is the same thing.
I guess what I'm getting at is it your view that you can never have an ineffective assistance claim on anything that is in any respect an open question, that hasn't been squarely decided?
Well, I think with respect to this case, it certainly was an open question and not clearly decided at that time.
Would a different articulation be that you can't have an ineffective assistance claim on a single error issue where it's not clear-cut?
I think that is the better way to formulate a standard if we were to create one with this case, because ultimately this is a claim of single error ineffective assistance, the failure to do the single act of failing to raise the Confrontation Clause objection.
And you think that's true even after John, even today? If a defense counsel failed to make a Confrontation Clause argument in a cold hit case, you would say that's not ineffective?
I would. If there are no further questions, the people will rest on our brief.
Thank you.
I'd like to, with the court's permission, push back on the idea that this was a classic cold hit case, but if possible, before that, I'd just like to continue the conversation that was just being had. Well, actually, no, sorry, I'll do that first. So a classic cold hit case is one where the DNA profile is produced with no suspect in mind. That isn't this case. Both of these DNA profiles were produced with suspects in mind, and in one case, it was Mr. Espinosa himself. Now, counsel could have refrained from making an objection, or had he made an objection, the prosecution could have argued that DNA profile of Mr. Espinosa was produced for a different accusation, not this one, and therefore it was testimonial as to that case, but not this case. But as far as I know, had the trial court accepted that argument, it would have been the first court in the United States, perhaps, to accept that argument.
Can you just explain that in a little more detail for me? Are you saying that Mr. Espinosa was a known suspect because he had been charged in a prior crime? Because my understanding was, other than the fact that there was some visual identification by one of the residents of the apartment, nobody had any idea who had committed the break-in.
That's right. So what happened was, in an earlier case, Mr. Espinosa was arrested in 2006. There was a court order to take his DNA. A police officer took it. It was sent to the OCME lab. They produced this DNA profile for the purpose of prosecuting him in that case. And then, a decade or so later, it was used in the trial of this case, but it was produced for the purpose of prosecuting Mr. Espinosa for a crime.
For a prior crime.
For a prior crime, but if you look at the definition of what's testimonial, in all of the Supreme Court's cases where it's addressed this, all of the majority opinions, it's always about the circumstances of the statement's production. It's never about the circumstances of the statement's use. The Supreme Court always says, and they've offered a few different definitions in Crawford and Davis and other cases of what's testimonial, but it's always
It's like, I'll grant to you that that's a very legitimate question, right? Maybe it's not what you would call classically testimonial here, but his DNA profile could very well have been testimonial in the prior prosecution. But that's a lot to go into on an ineffective assistance case. I mean, wouldn't the better thing to do from a judicial economy perspective to be wait for that case to come here presented fully on its merits?
Right. I think that's a reason to reject the prosecution's sort of counter-argument that would have been made to the objection had it been made in this case. In other words, to put that more simply, the objection would be straightforward. The objection is, this was testimonial, it was produced for the purpose of prosecution. The argument against that objection would be, I think, strange and trying to produce a new rule that has never been endorsed by any court, as far as I know, certainly hadn't been at the time of trial in this case. So in other words, the novel rule that shouldn't really be considered in this case is the one that the prosecution is advocating, which is that a statement loses its testimonial character when it's used at a subsequent trial of the same defendant. I'm happy to answer other questions on that, but I did want to just make one other quick note about what constitutes ineffective assistance of counsel, how clear-cut does it have to be. I think the touchstone of this court's jurisprudence on ineffective assistance of counsel has always been meaningful representation. And so the question is, what counts as meaningful representation within the context of whatever case is on the table? And when the case is entirely about DNA evidence, the only evidence of identity is this DNA testing, that's what the trial is going to be about. If there's an objection that could keep out that DNA evidence, doesn't meaningful representation mean an attorney who is familiar enough with the basic law that they know to make that objection? I think that's really the touchstone here. It's of course going to be different in different cases. It's going to depend on how clear it is that this is the wrong witness. It's going to depend on the centrality of the DNA evidence. But meaningful representation in this case at this time necessarily meant making this objection.
Thank you.
Thank you.